Hey everyone, John Waite here, bringing you another video on this year's forms changes from NC Realtors. Today we're going to cover the commercial forms. In case you haven't watched the other videos, the most important thing you guys need to know is that everything I'm talking about is on the website. So if you go to ncrealtors.org, you can hover over this right here, go to legal Q&As. It'll take you to this page here, and the Q&As are in chronological order. You can see the summary of all the forms changes are right here. We are going to go through the commercial changes today, so I'm going to click on that one. And when you click on that, it takes you to a page that talks about the summary, and it also has hyperlinks here to every single form that was changed with, strikeouts and highlights and added language and all things like that. All right, and we're going to go through just a highlight of the forms today, not all the forms, because there's substantial duplication in the edits that were made. I'll talk a little bit more about that in a minute. But you can see here that pretty much all the changes that were made had to do with the settlement that happened in March with NAR in the Burnett case down in Missouri. There's a couple others that we will cover, but pretty much I'm going to be talking about those settlement changes and how the settlement itself affected the forms and the changes that were made by the Forms Committee. By the way, big thanks again to everybody who's volunteered on the Commercial Forms Committee. There was a lot of work done on the forms that actually didn't end up in the final product, and that happens sometimes. And it doesn't mean that the work was not worth it. There's a couple things I think we may try again to work on this cycle that we didn't quite get across the finish line last cycle, but the members that are on those committees do a really good job of making sure that the forms reflect you and your practice, and then we try on the legal side to make sure that the forms are in compliance. I do want to take a minute just to address something that's been coming up pretty frequently before I get into the actual changes themselves. There's been, I've seen at least one podcaster who's not a lawyer talking about how the next wave of antitrust litigation may well center around whether you use standard forms or not. And I'm just here to tell you that I just don't see that with North Carolina forms. The NC Realtor forms go through an extensive revision process. They've been around a long time, and if you were asking me to make bets, our forms here in North Carolina are the reason we did not see a copycat suit here. Could we see one? Sure. There's nothing that's like bulletproof, okay? But when I look at the allegations that were addressed in the Burnett case in Missouri, and I look at how our forms already address that, including the commercial forms actually provided a real good roadmap for some of the changes we did in the residential forms. So, the commercial side has always been a section of the industry that has dealt with commissions a little bit differently, and in particular a way that would make the same allegations that were happening in the Missouri case just difficult to bring here. So, to the extent you see that kind of information, I would just encourage you, look at it carefully and, do as much research as you can on it. And know that the forms in North Carolina not only go through a vetting process with you, the agents, but also with attorneys, at the state level, as well as if it's a -T form, most of the time those are going to be joint forms that actually go through the real property section at the North Carolina Bar Association too. And guess what? Lawyers have about as much interest in getting sued as you guys do. So I assure you that these forms go through that kind of a process, and in particular, staff, Chief Legal Officer Caitlin Thompson, as well as other staff at NC Realtors, do a very good job trying to stay on top of antitrust issues and how they may arise in the forms and training materials and things like that. Anyway, all that said, let's move on to the actual changes in the forms themselves. I'm not going to, like I said, I'm not going to go through all of them today, but I'm going to talk about a few in particular, and then you can, look at the forms, other forms in that same vein, and know that the changes are substantially similar. So the first form we have here is Form 530. This form is an exclusive buyer-tenant representation agreement. There's two more forms that are substantially similar to this one. There's an exclusive buyer agreement and an exclusive tenant agreement. This one is either or. So I'm going to cover this one, and I'm not going to cover the other two because the changes are pretty much the same. Scrolling down, you can see the changes that were made to this form, and you have to understand that the settlement, the NAR settlement, really, when it comes to agency agreements, was looking at two things. One, that they want this part down here that's bolded, it and capitalized. It won't be highlighted in the final version of the form. The highlights are just to show you where the changes are. But the statement here, this disclosure here, that real estate commissions are not fixed by law and that they are fully negotiable, set by each firm individually. Okay, that is part of the NAR settlement. The funny thing is, it was already in many of the commercial forms already, substantially similar language. So some of the forms needed to have this language inserted a little bit differently, whereas others just needed a couple tweaks to the language because the language is already substantially there. Shout out to Garth Dunklin, who's unfortunately no longer with us, but I'm sure he had a hand in making sure that language is in there in the first place. Very, very forward thinking by him, and well done on that. In any event, so that's the first thing, was this disclosure about these sorts of things, and then up here you'll see some smaller edits. And what these edits are is to reverse the default of the form. It used to be the default in all the agency agreements, whether residential, commercial, whatever. The default used to always be that if cooperative compensation being offered by the seller was more than what the buyer had agreed to in the buyer agency agreement, then the buyer would consent in this standard language right here, consent like ahead of time. That the buyer agent could keep the additional compensation. That is no longer the case. After the settlement, now the client must agree in writing and has to do that separately. It can't just be done on the front end. It's got to be something that happens later after the client is informed about it. And so some of the forms later on that we'll discuss have been changed to accommodate that, to show that the buyer's consenting, especially with forms that address additional compensation and disclosing that to the client, which is required by the license law. It's been required for a long time. It's just that the process for additional compensation is going to be different. If you're a buyer agent, you need to make sure that when you are filling out this form with your buyer, that you are valuing your services. This section up here is going to be very important. It's going to, this is what you are agreeing to work for. And you may or may not be offered cooperative compensation by a seller. Now, granted, commercial's not going to see that much of a shift in how you guys do business, simply because, while you guys did sometimes use the MLS, it's not your primary form of communication. So, you're probably going to be moving forward. You're probably, if I had to guess, buyer agents in the commercial context are a little bit more adept at making sure this section is filled out the way it's supposed to, and a little bit more understanding of how cooperative compensation may or may not be there, and that the buyer needs to pay for the services that they've agreed to receive, regardless of whether that's done or not. Okay, so that's really the only two changes to this form, is just those two things. The disclosure about commissions not being set by law and being negotiable, set by each firm individually instead. And then, if there's additional compensation over and above what is up here, then the client needs to consent to that in writing. So that's really all these edits do. And I'm going to move on to the next form we have here, which is the non-exclusive buyer-tenant representation agreement. This form here is interesting, and I'm not sure how often it is used, but just understand that before, this form, this buyer agent form, first of all, it's non-exclusive. So just understand that, if you got a buyer or a tenant, you're using this form, it's non-exclusive. It means if they want to go hire someone else, they can. That's the difference between exclusive and non-exclusive, right? So here, there's a little bit edit to this note at the bottom, which basically used to say, we're going to seek compensation from the other firm. Doesn't obligate you to pay anything at all. We're going to represent you, and we expect to get paid. Okay, so there's still agency, but the compensation part is going to be worked out. This form here, I'm not sure how often it's used, and based on guidance that's come out since we did these forms changes, I do wonder if the way this form is worded is going to be, in compliance enough with the new MLS rules. So if you have a property that's outside MLS, I think that's a little bit different. You have to understand that the NAR settlement changes are all going to be policed and done through MLS policy/rules changes. So if you don't have something in there, if it's not through the MLS, then it's not something that is going to be effective. So I would just say be careful with this form. Outside the MLS, I think it's a much better. I think it's just a much better fit for particular transactions. Okay, if you're doing a non-exclusive buyer-tenant relationship. In MLS, I think that's a little bit different, and if you're shopping in the MLS, I think that's a little bit different. So just understand that, and understand that this is something that you may want to talk to before you start using this form. Something you might want to talk to your MLS about, and make sure that they're not going to have an issue with it if you're operating within the MLS. All right, but you can see here, this change at the bottom means the biggest change to this form used to be it was there wasn't language in there saying that the client had to consent in writing later. It was just going to be something that was worked out, and here you go. But that's not going to be the case anymore. Now the buyer or tenant must consent to any cooperative compensation in writing before you're going to be able to enter into an agreement with the listing firm on the buyer agent side. All right, up next we have Form 541. This is a commission split agreement in a sales transaction. I'm not going to cover the lease transaction because it's the same. And the edit we have to this one is a new signature line, and it is so that the seller and the buyer can consent to the split in writing. Since the client's got to do it anyway, this form is used, generally speaking, when there's a prospective buyer. This is the key term right here. See, there's a prospective buyer. There may or may not be a contract yet, and then there's the commission space in here. This is substantially similar to Form 220 for you. Also, people doing residential transactions, they've been trying to figure out how to use that form. Form 541 in the commercial library is substantially similar, and will operate much the same. You can think of it as like a Swiss Army knife, to have a way to document cooperative compensation in a transaction so that it's reduced to writing. Here, the buyer and seller, consent to it by signing and agree to the split. And so that's the only change to this form, so that when you have a split, you want to make sure your clients are agreeing to it. There's been some questions on Form 220, and I guess I'll just bring it up here. If you've already got client consent in writing, somewhere, say your agency agreement or whatever, then you may not need this form. It might be a good idea just to have extra confirmation, but just understand that it may or may not be necessary depending on how your agency agreements are structured. So try and, I understand that there will be, as we make this change, some confusion with some of the overlap of the forms where, you can basically solve a problem more than one way. I think that is, something that's not a bad thing. And I think agents will eventually figure out the most efficient way. And then if something becomes unnecessary, then the forms committee and those volunteers will look to see whether it's necessary anymore or not. They delete forms all the time when they don't become necessary, when they seem unnecessary based on just practices in the industry. So just understand that that's something that the commercial forms will look at, and something that that committee will discuss over the coming year. Moving on to the confirmation of compensation. This is similar to Form 770 in the residential library. It's a disclosure to your client about potential additional compensation that may be coming around. You can see a small edit here that when your client signs it, they're indeed consenting to it and not just being told, hey, this is what's happening. They have to actually consent to additional compensation. Again, additional compensation is something that's required by the license law. If it's not already in your agency agreement and it's something that comes up some other way somehow, then this is a form that you would use to inform the client about it, and now additionally get their consent. All right, moving on to the exclusive right to lease or sell listing agreement. This is Form 570. You can see here there's a note added that you may use Form 541 or 542 as applicable. So 541, this is this commission split agreement. The 542 is the same thing, just on the lease side. So that's what this is referencing. Otherwise, you could see as you go through this form here, not a lot of edits except for right here. All we had to do is put "are fully" in here because it was already set out pretty clear in here that commissions are not fixed by law and that they're set by each broker individually and fully negotiable. It was already had negotiable, just had to add fully. And I don't think there's any other change. Yeah, no, that's it for this form. So you can see like how much, especially in the listing agreement side in the commercial library, already in compliance with the NAR settlement. And I understand, like, as I talk to agents, especially on the hotline, during this process, there's been some confusion of just like, and even a lot of frustration, like, what are we doing? Why do I have to do all this? And I am totally sympathetic to that, and it's just one of those things where it's out of our control, really. But if you want, if everyone else was doing it the way we're doing it, does that mean we wouldn't have this result? I don't know about that. Would it have been a more difficult case? Yeah, probably. So it's just one of those things where it's frustrating sometimes for agents to hear, well, our forms are already in compliance with this anyway. Why do we have to do all this and make all these changes? And it is simply because, as we move forward as an industry, for me personally, just thinking about it from a strict, antitrust and just a risk management perspective across firms, across the industry, I don't think these changes are bad. They are difficult. I mean, you won't get any argument from me there. And I'm completely sympathetic to that and try to help agents as much as possible. But at the same time, they're not going to be all bad, I think, in the long run as agents figure out how to navigate, and especially in the residential side, practice a space where cooperative compensation is not out there in the MLS all concentrated in one spot, which presented obviously antitrust concerns. All right, moving on to Form 573. Here, we just have some cleanup of this language here to make it a little bit easier for the firm to register a prospect with the seller. Not so formal. The Form 510 didn't exist anymore anyway. So, the language had to be cleaned up, and then as part of that, if you want to give a seller, if you want to register a prospect with the seller as part of this, agreement, then you just got to do it prior to showing the property by getting seller notice the prospect, either orally or in writing. Now, should you do it orally? No, no, and I don't think any of you really think that that's a good idea. So I'm not going to harp on it too hard. But you definitely, if you got a seller, it's non-listed property, you definitely want to give them notice in writing so that you have documentation of that. Email will work fine. Email is a perfectly acceptable writing. Form 573, for those of you who don't know, and for those of you who maybe don't use this form, it's a non-exclusive agency form. And so you can see here the agreement, this agency agreement is entered into between the seller and the firm. And as you check the boxes down here, you may if the seller agrees, you could be the seller's agent. It would just be non-exclusive. Or B, you could actually be a buyer's agent and not have any agency with the seller at all. And then you identify the property. So this form is a really interesting form. It is sometimes one that I will recommend for residential transactions too, depending on the circumstance. You can see here we have the notice that's been inserted, and then there's nothing about additional compensation. Your fee is your fee, and there didn't need to be any edits to that. So this form is, it's a non-exclusive agency form, but it's in compliance with the settlement and the license law, and ready for you guys to use if it fits a particular transaction. A lot of times commercial and residential brokers will call and have a situation that's a little strange, and this form fits surprisingly often. So if it's not a form that you are familiar with, it's one that you might want to become familiar with. And then we have the commercial lease agreement, and so we're going to sort of check out of the NIR settlement changes and look at this here. The forms committee, the commercial forms committee, wanted to clean up this section and just when you look at the final product, it's going to be very streamlined with basically rent adjustment being simplified with 3 check boxes, and it should work and be a little bit easier to read. Hats off to this committee for prioritizing, just trying to make sure the form is user friendly and easy to read for both agents and clients. So that was part of that section there. And otherwise, the section itself operates substantially the same, but hopefully it'll be a little bit easier to read and use. There's a little note here to make it clear that these utility obligations are in addition to the obligations in section 12. And if you scroll down to section 12, I'll show it to you really quick here. It has to do with repairs. And here, this is this HVAC section. We've labeled these two check boxes so that you don't have to try and figure out which is which. This is where the tenant's going to do the HVAC repair, and this is where the landlord's going to do it. So read through those languages and make sure that those sections, and make sure you check the appropriate box as far as HVAC repair goes. But we've labeled them to hopefully make it a little bit easier. And I think that's it for this form. Minor edit here, changing twice to double, but hopefully that makes sense. If there's a holdover situation, there's no right to stay in there. It's just double rent. So if you're not familiar with that, you might want to know that paragraph is in this lease here, Form 592. All right. And sorry, one final note about Form 592. It's the commercial lease agreement for a single tenant facility. Obviously, there's multiple tenant facilities, and with that, which affects common area things and things like that. That's Form 573 or 593, and here it is right here. Now, 593, interesting edit to this form because the exhibits are now the same in here as they are over here. So if before you were using these two forms and you always had to try and remember what's Exhibit A and what's Exhibit B, that you're no longer going to have to remember which is which. Form 592 exhibits match up with 593 exhibits, where Exhibit A is going to be the property, and then Exhibit B is going to be renewal terms and things like that. So those are all meant to be the same. You can see the same change here with the rent adjustment in the multiple. Same here with section 12. And let's see if there's anything else in this particular form. You can see here again a note to Exhibit B. It's not Exhibit C anymore. And there was one more area I thought, here at the very end. Now, if this box checks, there's Exhibit B, or if the box is checked and proved to the premises set forth in Exhibit C. So just understand that, if you on the exhibits, if it was something you were having to keep track of before, you're no longer going to have to. So try to remember that and educate your clients about it. All right. Let's see, I probably need to log in to do this next part because I forgot to bring up this form. So let me bring up this form I need real quick. The next form that I'm going to bring up is if you have existing agency agreements. The forms committee got together and did one more brand new form that came out just a couple weeks ago. And I'm going to bring it up here. Well, hopefully it'll come up. Hopefully it'll come up pretty easy. I just want to talk about it briefly. And there we go. Perfect. All right. So this is new form 715. I just want to, you can see here, every single agency agreement that is in the library for NC Realtors is here at the top. This is meant to bring old agency agreements into compliance with the new MLS rules. You can see here that the compensation disclosure, as I talked about before, is right here, and then additional compensation is here. And basically it says when it comes to additional compensation, instead of the client automatically agreeing to it, now they have to agree to it separately in writing. And that's pretty much it. All the other terms and conditions, including any amendments to the agency agreement that you're attaching this to, all the same. I will take a minute and just say, if you have a client who doesn't want to sign this, which I don't know, it's a little strange to me because both of these things benefit your client. But if you have a client that doesn't want to sign this, at least give it to them and just mark on it, that they refuse to sign. That way, at least you got documentation that you gave them the disclosure, which is required. And then If an additional compensation issue comes up in the transaction, feel free to give a call to the NC Realtors legal hotline and we'll walk you through it. Depending on the circumstances, it may be something where you'll be able to navigate it one way or the other. But as far as giving just blanket advice on how to handle those situations, I think it's best handled on a case by case. So that's been the guidance. There's a Q&A that came out when this form was released. NC Realtors released a Q&A on it, and that's what was in there. Hopefully you guys have seen that. If you haven't, check it out. It is right here. So it came out July 3rd. All right, that's all I got for you guys today in the commercial forums. Hopefully this is helpful. If you have any further questions, feel free to reach out to the NC Realtors legal hotline and we'll get you squared away. And I'll see you next time.